So welcome, Marc Blonstein.
Hi, everyone. Marc Blonstein. My law firm's name is Berens Blonstein. We have been in business I've practiced for about 25 years, principally in the real estate area. We do all kinds of real estate, from land investments for home builders, developers, master plan communities, to office and industrial, to retail, both on the transaction side and the leasing side, and about everything in between. My practice is all transactional, don't really handle any kind of disputes, but when it comes to getting to the deal, that's us. So that's what I've done for the last 25 years.
Perfect. Well, welcome aboard. A lot of people are calling us, or landlords are calling us, what should a landlord do if they receive a letter from their tenant requesting rent abatement? They can't pay their rent, they don't want to pay their rent. What's a good response? At the same time, a lot of landlords have a mortgage, so there's probably a couple steps that they should or maybe should not be doing to protect themselves.
That's a very detailed question you've just asked. It has a whole lot of different
we could look it up if that would be easier.
Well, and that's okay. I mean, I would say to start, I mean, you have the legal answer, and then you have the practical answer. The legal answer is, if you get a letter saying, I'm not going to pay any rent, well, under your lease, you probably have the right to say, well, you are in breach of the lease, give the appropriate notices, and take whatever action you have that you want to take. But at the end of the day, again, there's a couple things we need to talk about there, but at the end of the day, you probably want to still have a long-term relationship with that tenant. And so putting them in breach and taking action to evict them is not really going to get you what you want. What you want is the tenant to stay in place long-term. So, I think, that's the legal answer. The asterisk by the legal answer is, in a lot of states, and, in Arizona in particular, where we're located, the governor has issued an executive order that says, regardless of what your lease says, you cannot take in commercial leases, you cannot take enforcement action to remove a tenant, lock out a tenant, or otherwise before May 31st. And again, that date may be different depending on the state that you're in, maybe in a state that doesn't apply. But in Arizona, that's the case. And what that does mean is you can't evict them. What that doesn't mean is that the rent is forgiven, that you can't assess late charges, you can't assess, default interest or whatever else your lease may provide. It just provides a window to say, look, we're gonna temporarily hold things until we hopefully get to the end of this thing, and then we'll reset and go from there. So that's really kind of the legal side of it. The practical side is, if your tenant comes to you and says, I can't pay my rent, you ought to engage with them and you ought to talk with them. Again, what we've been telling our clients is, you shouldn't treat every tenant alike. I mean, I look at our law firm, for example. We've been particularly busy, with all of this, because we get a lot of calls from our landlord clients. So if we were to go to our landlord right now and say, we'd like a rent abatement because, times are tough, they ought to look at us, laugh, and move on. But if if your lease is with a restaurant and all the restaurants are shut down except for takeout only, and the revenue is down by, 70%, you ought to be, engaging with them, talking about that, and treating them differently than you might treat somebody who's not as affected here. So, that's generally our advice, is when you get a letter like that, you should have that, how you have that conversation. I think you need to protect yourself as a landlord and make sure that what you're not doing is leaving things loose and informally saying, well, we'll overlook the payment of rent and we'll talk about this next month and see what happens. And actually, we on behalf of another client, we got a hold of a letter that I really like, that is really, I think, kind of professionally done and tenant friendly, and that you're saying, hey, Mr. Tenant, we understand the scenario you're in. We haven't received your April rent, and we're acknowledging that. However, you need to understand that, we encourage you to reach out and talk to us, but until we actually reach a new written agreement, this does not mean that we're waiving any rights, waiving any remedies, et cetera, et cetera, et cetera. And I think something like that, I mean, most tenants will understand that. And if they don't understand that, then, they're not really in touch with reality, because like you say, the landlord's got obligations. They have a mortgage to pay often. There might be like, and again, I know a lot of the stuff that you guys handle, it's triple net stuff where the tenants pay things directly. But if you are a landlord that has to pay like a common area charge or other charges, I mean, those charges don't go away just because the tenants close down.
Sure. Good response. Thank you for all that detail. There's a lot to.
That's what you get when you ask a lawyer.
So what are the main do's and don'ts, especially if we are in the triple net space, dealing with single tenant freestanding buildings? So are there do's and don'ts for a landlord based on what's happening?
Well, again, I mean, this is just my 2 cents worth, and I guess another kind of precursor to all this is it changes frequently. People have different opinions and experiences, but in our experience, I don't know that there's a specific list, but what I would say that the absolute do is engage with your tenants. Don't ignore them. Don't just draw a hard line and say, they can go see. Even if you think they're gaming the system, and just asking for something that they really shouldn't receive, you should be talking to them and not just ignoring them. The don'ts, and this, I mean, this kind of leads into another area, is, don't just amend the lease without really thinking through the ramifications. If they say, well, I just don't want to pay rent for April or May, well, are they going to pay it back within 2 years? Are you going to extend the term for a couple months? How is that going to be handled? And probably most importantly, if you have a loan on the property, what do your loan documents say? So we just went through one I would say we're still going through it, but we just finally got approval of the lender where the tenant had asked for a concession, and our client was a little bit more generous than what the lender was willing to accept. So we were willing to defer a couple of months, add it to the end of the term, and go on. Well, we submitted that to the lender, and the lender said that they had come up with parameters that it really didn't matter what the deal was. They didn't look at them individually, but in every deal, they were unwilling to accept a lease amendment that deferred the payment of rent for more than 90 days, and any forgiveness was a no-go. So, here we are, and, luckily we asked the question, but we go back to the tenant and say, look, this is what our lender will allow us to do. And ultimately the tenant was agreeable to that. And again, we're negotiating the fine points now, but, you need to be very careful that if the lender has a right to approve lease amendments under your loan documents, that you don't just go and amend the lease and now you find yourself in a problem with your lender.
Yeah, definitely a lot to digest. These are not, and this feels like each day is different. Feels like we're in the, first or second inning of what is going to be maybe an extra inning game, if I'm using a baseball metaphor. So yeah. We have a journey ahead of us.
Yeah, and I guess thinking back, I mean, that is something that's a little, it does change frequently. And in the beginning, I think, a couple of weeks ago, the MO was for landlords just to shrug their shoulders and say, look, just don't pay your rent, pay what you can pay. We'll see what happens. And I've noticed a pretty significant difference between then and now. It's not that landlords are being more aggressive in requiring payment, but they're saying, look, we need to be a little more formal here. And if we're going to give you something, we need to document that properly, make sure we have all the approvals, et cetera.
Sure. Yeah, great information. Is there anything you want to add also as a closing remark? We've taken some of your time, and this is something intended to be valuable for people that watch the video on the landlord side, a lot of investors out there that are concerned and not sure what to make of all this.
I was thinking about that earlier, and I think it's really, again, just be thoughtful. Be thoughtful about what you can and can't do. treat everybody differently. And I realize, again, your practice is, often you're just dealing with a single tenant. So, you need to look at each of those tenants a little differently and make sure that you're doing things the way they're supposed to be done under your loan documents, so that you don't inadvertently step in something which you shouldn't.
Perfect. Marc, thanks for joining on this beautiful Wednesday afternoon. It's tax day, and taxes are, I guess, not due today.
That's right. July 15th.
Right.
Actually, can I add one thing? You
Sure,
just reminded me
please.
of something. Everybody, and I know this is your business as well, the 1031 deadlines. I just finished a seminar where if your identification date and your closing date falls within, I think it was April 1st to, I don't remember the outside date, but they have bumped those dates to July 15th. So that, can be helpful depending on where you sit in your exchange.
Yeah, it's interesting that you bring that up. We had a client just yesterday reach out to us to sell his triple net property, knowing that he had more leniency on his 1031 timing, to group those funds together with another exchange deal that he's working with. So there's ways for people to work these dates and changes to their advantage.